Hello, I'm Charlie Shane. I'm an attorney in Washington State, and I wanted to talk to you today about alternate dispute resolution, or ADR. I think I'm often surprised at how little people know about ADR and how it works. So there are basically four types of ADR. One is a settlement conference. And what a settlement conference is it's a conference where the court will use a judge, or typically a judge or an experienced attorney to act as a mediator. And it's put on by the county. You don't have to pay for it. If you hire a lawyer, of course, you'll have to pay for your lawyer's time. But it's put on by the county, and it usually lasts about 4 hours. So typically, or less. So typically we're talking about 1:30 to 4:30 or 8:30 to noon. Or 9 to noon. Actually, I think it's 8. Anyways, it varies slightly, but a lot of times in the counties, this is a prerequisite before, in a family law case, before you can set the case for trial. So you may be eager to get to trial, but they're not going to let you do it until you go to these settlement conferences. And if you don't come to an agreement at the settlement conference, then they will give you a trial date. Everyone will look on their calendar and they'll give you a trial date at that time. The way these settlement conferences work, it'll vary slightly from county to county, but typically, at least in the county I frequently practice in, Kitsap County, it will be via Zoom. Other counties, you will show up in person. And some counties will only do the settlement conference if there is sort of a financial component. The parties can't really afford mediation. Other words, they'll expect you to do mediation. I think like Snohomish and King counties expect that. But the way that it works is that, especially in Zoom, the parties will start out in the same room, and then the judge will put you each in a separate chat room. Some judges like to try to have all the parties in the same room. It's rare, but sometimes it happens. I had it really only happen once in my career, and we actually reached an agreement. But this particular judge was a little bit scary, so I think she kind of bullied everyone into an agreement. But typically you'll do it, if you do it via Zoom, you each go into a chat room and the judge will pop between the chat rooms and try to facilitate an agreement. And we try to get agreements on all the issues. So if you're going in on a divorce, parenting plan, child support, property division, all the major issues, maintenance, child support, and that sort of thing. One sort of strategic tip, though, is if you have some issues that you're pretty far apart in going into these settlement conferences, you may want to focus more on the ones that you aren't, because sometimes you can get an agreement on those particular things, and then you just go to trial on the ones that you're far apart. Sometimes as well, some counties allow for subsequent settlement conferences, even if you don't come to an agreement, so you get that additional time to work on those issues you weren't quite able to work out. If you think it's going in a good direction, this isn't mandatory, but it's something that you can do. I know Kitsap County does that. If you reach an agreement in a settlement conference, one of the nice things is that you will then go into a courtroom, whether it's virtual or actual courtroom, and you will put that agreement on the record. So it'll all be recorded, and you can pay to have it transcribed later if you want to, but it'll be recorded so that the agreement's on the record. And then the next step would be to put that agreement into the final documents. So if it's a child support modification, you typically don't do these on those, though. Let's just say it's a parenting plan modification, which you don't have to do it on those, I think, either for a modification. Let's just say divorce, and you come to an agreement on the parenting plan. Then you would outline what the parenting plan would have. You kind of go over the sections of the parenting plan and enter the agreement. Now, sometimes if you have a parenting plan ready to go, you can actually just have everybody electronically sign the parenting plan, and then the judge will just sign off on it. It's important that you've taken the parenting class, because every county has a parenting class, before you go into these things, so that you're all set to go. But it's nice to be able to put it on the record, and then if there's a dispute, you just pay to get it transcribed, and you go in and say, hey, the court should enter the orders like this because this is what we agreed to. Now, we'll talk a little bit about a mediation. A mediation is different from the settlement conference in a few ways. One is, in a settlement conference, you don't get to pick who your settlement conference judge or attorney is going to be. You're just kind of stuck with whoever you get. And some judges are better at it than others, and that's okay. But you don't get to pick. And, I want to put one common misconception for settlement conferences and for mediations. So people will go into these things thinking, okay, well, we're going to make them come to this agreement. We've got a judge there. That's what's going to happen. The judge is going to make them. No. There's no decisions that are made. If you don't come to an agreement, nobody has to come to an agreement. And if you don't come to an agreement, it simply gets set for trial. The judge that happens to do your settlement conference also is precluded from being your trial judge as well. And that can be a bummer if you've got a great judge doing your settlement conference, and then you got to go to trial. Well, too bad, so sad. You can't have that judge. Okay, so let's talk about mediations. Mediations are like settlement conferences. A lot of times they are done via Zoom. In fact, that is my preference. I found it's easier and you get the same results. The nice thing about a mediation is typically you can set them for all day. And so if there are a lot of issues, there's a lot of things to work through, you definitely want an all-day mediation. That's one of the major problems with the settlement conferences. A lot of times there's simply just not enough time. You've got to work through a lot of issues. The parties need to feel like they've been heard, and there's just not enough time in a settlement conference to do that. So you work through these issues. It's like a settlement conference. You're typically in separate rooms, whether that's virtual rooms or actual rooms. If you go to a place, which, like I said, I typically prefer not to. I think Zoom is way better, way easier for everybody. It's easier to do it in the comfort of your own home. Sometimes attorneys will have people come to their office, and I just think that's silly. I think everybody should do it in the comfort of their own home. You have plenty of time to talk when the mediator or the settlement conference judge is in the other room. Then you can talk, and then they suddenly appear, and then you listen to what the judge has to say and talk with them at that time. But the nice thing about a mediation is you have all day, so you have more time. You're not in as much of a time crunch. And sometimes I've had them go as late as, I think, 10:30 at night. It just kind of depends on your mediator and the situation, but they can go past the time. And you can also do subsequent mediation. So if you're doing well and you need more time to work out the other issue, you can schedule it for another mediation. I typically don't do that. There are mediation services which will do several mediations broken up over time. I've tried that once. We were able to reach an agreement. My personal preference, I think, is I like to do it all in one shot or close to one shot. I think either you're going to do it or you're not, rather than drag it out over time. But sometimes dragging it out will encourage the parties to settle as well. But like I said, my preference is just one mediation right there. I did this other one just because the client had already started on that particular path, and so we just finished it. The other thing about a mediation is you have more time, and then if you come to an agreement, it doesn't go on the record, but at the end of the day, you have one of the attorneys will typically put together a written agreement which reflects what everyone agreed to. And so and everybody signs it, and then you put your final paperwork together. And if there's disputes, a lot of times I like to include a provision in the actual agreement which says that the mediator has authority to arbitrate those disputes. There's actually a whole lot more to talk about. I just kind of wanted to give you guys an overview of some of these methods. We're kind of running out of time, so I think I will save for another video. I will talk a little bit about arbitration, and I can also talk about other topics such as preparing for settlement conferences and mediations, things that you need to do, things that your attorney needs to do, but we will save that for another time. I hope you have a fabulous evening or day wherever you're at, and until next time.